Welcome to Court Helicopter News, our normal segment of explainer, coming to you from Court Helicopter, explaining to you the law and trying to demystify some of the mysteries and stereotypes that Kenyans don't understand, but we put it the way it is. Today's topic is about what is plea bargaining. People saw the former governor of Migori County, Obado, where the DPP walks to court and says that there is a plea bargaining agreement. What is really a plea bargaining agreement? In a criminal trial, an investigator investigates a complaint, gets all the facts, forwards that file to the Director of Public Prosecution, and the Director of Public Prosecution, if he is convinced that there is enough evidence, he will prefer charges. The accused person shall be brought to court. He takes plea. Here, the accused person pleaded not guilty. Obado pleaded not guilty and the trial started. Midway, Obado or the accused person can write in writing to the Director of Public Prosecution seeking for a plea bargaining. There are rules that have been passed that deal with plea bargaining. In the rules, what happens? The accused person and the prosecutor will discuss together with the victims, those who complained, and the prosecutor will look at the options available. The plea bargaining agreement is that the accused person is ready to change his plea from being not guilty but to being guilty. There are charges. If somebody was given 20 counts to plead, the prosecutor can agree that we are going to charge you now for 2. We drop 18. Or we are going to charge you for 1. We drop 19. The accused person, if he was charged with money, he had stolen, for example, Obado case, he had stolen money of the public, he might say, I'm ready to return 3/4 of the money, or I'm ready to return the whole amount that I'm being charged with. So after this agreement, if the victims agree and the prosecutor agree, a plea bargaining agreement is put in place. What is the role of the victim in this matter? The victim must agree with the plea that is being done. This plea bargaining can be in offenses of murder. It can be in any matter that one has been charged about. Then the investigator, for example, in Obado matter, Kenyans saw the investigator saying that they were not part and parcel of the signing of the agreement. The role of the investigator in this matter, if it is EACC, the role of, or DCI, the role of the investigator is to be informed that the proceedings in terms of plea bargaining are going on. Once the plea bargaining agreement comes to court, the court has the final say. The prosecutor, the accused person, the victim can come with a plea agreement to court. That agreement does not bind the court. In the plea bargaining agreement, they will be recommending the type of sentence that the court is supposed to give, but it is not binding. The court can, one, reject the plea bargaining agreement. So Obado's request and the DPP's request for the plea bargaining to be adopted by the court is likely, one, The court can reject, and if the court rejects, the trial proceeds, and until the end, the court will convict or acquit. Number two, the court can agree the plea bargaining agreement but vary it. It can vary the recommendations. If the plea bargaining agreement that was saying that he should pay 500 million and the court feels that he should pay 600 million, the court can vary those conditions. Lastly, the court can adopt the plea bargaining agreement as it is. Why is plea bargaining agreement the new way to go about? Article 159 of the Constitution provides for alternative dispute resolution. Plea bargaining agreement reduces the time a matter is going to be in court. A plea can be taken today. Within 30 days, a plea bargaining agreement has been done, and that matter is settled and convinced. Two, a plea bargaining agreement is a better way because sometimes the victims, the complainants, feel satisfied. There is compensation, their matter has been resolved in a faster way, and the relationship that was there previously is restored. So, it is now the way to discongest criminal courts, because a trial is a very expensive affair. A trial is a long, it takes a lot of time to conclude, and that is why now the law on plea bargaining is taking momentum. Which offenses can be entered in plea bargaining? Any offense can be plea bargained, and that matter comes to court for the court to decide what is supposed to be done. So, Court Helicopter today has explained to you that sometimes you do not need the case to proceed all through up to the end. You can plea bargain by entering with a discussion with the DPP. Two, another way that matters can be resolved in criminal matters is for the parties to settle, agree, do compensation, and walk to court so that the matters are withdrawn. One of the ways to do this is the complainant will come to court, swear an affidavit, and say that I have already been paid my money, and therefore I do not intend to proceed with this matter. And that will mark a closure if the court agrees with the withdrawal of the case by the applicant. So the DPP can move a plea bargaining agreement, or the complainant can move to court and request for withdrawal of a matter before the court. Therefore, plea bargaining is the way to go so long as the court approves that matter. Wakili Danstan Omari on the explainer on what is plea bargaining, and in light of what happened in the governor's case of Governor Obado. Thank you very much.